Last week, an independent commission of inquiry from the UN Human Rights Council found that Israel had committed genocide against Palestinians in the Gaza Strip. Israel denies that its conduct in Gaza has broken the treaties and conventions that make up the laws of war and international humanitarian law. It justifies its actions as self-defence against Hamas, a group that the EU and others list as a terror organisation. The latest report has intensified scrutiny on what Germany, one of Israel's closest allies, is doing to intervene. The German government insists it's using diplomacy to urge Israel to show restraint in Gaza and has restricted weapons exports to Israel. Some legal experts are warning that Germany is breaching its obligation to intervene, which could do lasting damage to international law. I discussed this with Janina Dill, co-director of the Oxford Institute for Ethics, Law and Armed Conflict. I began by asking her what legal consequences Germany could face as a result of its support for Israel.
Germany is already facing legal consequences for its support of Israel. There are several cases pending before German courts regarding the particularly continued arms exports to Israel. And there is a case pending before the International Court of Justice brought by Nicaragua, which alleges, amongst other things, that Germany is failing to prevent genocide, complicit in genocide, and also failing to enact its duties under the Geneva Convention. So Germany is already very much facing legal consequences for its support of Israel.
How does the UN report increase the pressure, or does it increase the pressure on Germany and other states to act?
So there are two ways in which Germany could be found in violation of the Genocide Convention. One is the failure to prevent genocide, and that duty to prevent genocide kicks in at the moment where a state reasonably becomes aware of a serious risk of genocide. And arguably, the risk of genocide has been there for many, many months. So in some sense, the failure to prevent is something that already there's significant legal jeopardy that Germany might be found responsible for that. But there's a second way in which Germany could be breaching the Genocide Convention, which is complicity in genocide. And here the threshold is significantly higher. Generally, the understanding is that for a state to be complicit in another state's genocide, there needs to be awareness or knowledge of the perpetrator's genocidal intent. And as you know, it's very contested whether there is genocidal intent, whether that can be attributed to Israel. And here, I think the report is an important piece of the puzzle. It is, brings forward quite plausible arguments for why, from the perspective of a third state, there should now be awareness that there are individuals acting with genocidal intent in Gaza. And the report makes the case that this is attributable to Israel. So it contributes to the awareness of genocidal intent for states like Germany, and so raises the risk that a state that continues to support Israel materially could be violating the duty not to be complicit in genocide.
Okay, but you mentioned that there's a higher threshold to prove complicity. But if we take then this idea that the states have a duty to prevent, that it stems from the responsibility to protect. Describe to me exactly what that responsibility to protect convention is, what it contains.
So let's return to the Genocide Convention, right? The responsibility to protect is in the first instance a political concept, but there's a very specific legal duty to prevent genocide that is actually spelled out in an international treaty, the Genocide Convention, which has prevention in the title, right? So this is a concrete legal duty that all states have. And we know that at the point where there's a serious risk of genocide, states must use all reasonably available means to them to attempt to deter the genocide, to influence the would-be perpetrator of genocide to change course. That is quite a concrete, uncontested legal duty. And in some sense, the International Court of Justice already in January 2024 alerted states in the world that there is a risk of genocide in Gaza, because it basically said that Palestinians' rights under the Genocide Convention are at immediate risk from Israel's conduct. So at that point in time, already states were put on notice that there is a risk of genocide. That's quite different from saying we can definitively establish a genocide, but a prevention duty obviously must kick in before an act is completed, or it's not much use.
Okay, so Professor, then what are countries like, in this case, Germany, expected or obliged to do to prevent a genocide?
So every state that is a member of the Genocide Convention has a duty to use its capacity to influence Israel to change course. Capacity to influence can look quite different depending on the bilateral relations that a state has with Israel. It would definitely suggest not sending weapons of war or armaments generally to Israel. So an arms embargo would be the first step for states to influence Israel. Trade sanctions, suspension, a more fulsome suspension of trade relations, diplomatic protests, these are all means that are reasonably available to a state to influence another. Generally, means to influence must themselves be legal, so they can't violate international law. But other than that, there's a panoply of options that states have, and particularly regarding Germany, we really haven't seen the German government even attempt to exhaust its capacity to influence Israel.
Here in Germany, the response to the UN report has been that Germany will wait until a court has had its say on whether or not Israel is committing genocide. Is that a valid and understandable position?
That's an unbelievable logical error, because a prevention duty is obsolete at the point in time where a court says the genocide has occurred. If we look at the existing cases of genocide before the International Court of Justice, there are two that reached the merit stage. It took over a decade for the court to determine whether there was a genocide. At that point, it's going to be too late. Too late for the Palestinians, but also too late for the international legal order to have worked in the way it should. And it's certainly going to be too late for Germany to demonstrate fidelity to law. It's very hard for me to understand or believe that someone could look at a legal duty of prevention and suggest we can wait for a court to tell us whether we should exercise their duty, when logically at the point in time where the court tells us that there was a genocide, the duty to prevent can no longer be discharged.
German politicians, since the 7th of October attacks in 2023, have talked about this unique relationship that Germany has and a kind of responsibility that Germany has to Israel's right to exist. And that, they say, in this relationship, they say, allows it to put pressure on Israel like few other countries can, because it's an ally that has underlined its support for Israel. But at the same time, they would say that they are working to ensure that humanitarian aid is delivered, that the Israeli government shows restraint. Could they justify that as being the government, in a sense, acting under their right or their responsibility to prevent? Is that them applying pressure? Is that enough, essentially?
Well, it's right that enforcing international law or demanding compliance with international law is more effective if you do it with your friends and allies than if you do it with your enemies. It's more effective, but it's also politically harder. And I just don't see the German government having seriously attempted to put pressure on Israel, because asking for the delivery of humanitarian aid has proven largely ineffective. Palestinians are still suffering. There still isn't enough aid. And what Germany has done is it has diplomatically shielded Israel from UN measures that might have been effective in imposing a ceasefire, for instance. It has for a long time diplomatically shielded Israel from the European Union speaking with one voice and imposing stronger sanctions and stronger trade sanctions. So there are very clear avenues via which Germany could have put pressure on Israel. And I agree with the notion that Germany has these avenues partly because it has a strong diplomatic relationship, even friendship with Israel. But Germany has chosen not to pursue these avenues and has in some sense hidden behind the idea of simply asking for compliance with law, asking for more humanitarian aid, but never clearly articulating that A, Israel is not complying with law and is not letting enough aid in, and B, then articulating the expectation that unless that changes, there will be more serious sanctions that actually hurt Israel. That is how you create a deterrent effect, not simply by publicly saying, well, we would really like legal compliance and humanitarian aid. You have to say what happens if there's no change in course.
Germany has been very vocal in other instances of alleged genocide, including in Myanmar. Can you explain this difference in the German position?
In the case of the Gambia versus Myanmar, where the Gambia alleges that Myanmar is committing a genocide against the Rohingya, Germany, along with a number of allied states, has intervened as a third party with a declaration that has urged the court to consider certain doctrinal matters. And one of them is the notion that genocidal intent should be inferable from a pattern of conduct. So we can imagine a genocide like, for instance, the German genocide of the Jews, where you have an explicitly articulated plan to destroy a group in whole or in part. And that is then direct evidence of genocidal intent. But much more often in history, a perpetrator of genocide doesn't articulate that kind of plan that provides direct evidence of genocidal intent. And so what we're left to do is to infer that intent to destroy a group in whole or in part from the pattern of conduct before us. And here the court has said that to do that, it must be the only reasonable inference from the conduct. That doesn't mean it must be the only purpose that animates conduct, right? But it must be possible to look at how a perpetrator behaves and say, we can only explain this conduct if the intent to destroy the other group is one animating purpose. And so Germany has cautioned in this case that that standard may preclude us from actually diagnosing genocides that happens, and has made a number of recommendations of what the court should do to make sure that this basically doesn't undercut its ability to diagnose genocide. And of course, that the impetus behind this stands in stark contrast with how Germany has reacted to the allegation that Israel is committing a genocide in Gaza, where it has very much pointed towards this incredibly high evidentiary standard for genocidal intent as a means to say, well, we don't think there's a genocide, we can't be sure, it's a horrible allegation.
How does German history, the Second World War, the Holocaust impact how Germany is handling these allegations against Israel in 2025?
So I think we need to distinguish between how German history is impacting the way Germany is positioning itself towards Israel and how it should do that, right? We can see very clearly that Germany is somehow attempting to deal with its history by not holding Israel to account, by not speaking out clearly, even by shirking its own duties under international law to, in some sense, protect and shield Israel diplomatically. And it's quite obviously linked to an attempt to deal with our own history. This is a mistake. It's a mistake morally, and it's a mistake legally, right? In some sense, I think from our history, if anything, arises a stronger duty to stand up for a victimized group. And as we've said already, there's a stronger means, a stronger capacity to influence Israel that stems from the close friendship and diplomatic relations that Germany has with Israel. So it's nothing less than tragic to see that we have drawn the opposite lesson from our historical past than we should draw.
What potential repercussions then could a third state, in this case Germany, face if it is found not to have fulfilled its responsibility to prevent a genocide?
So we should acknowledge that there are very significant doctrinal and jurisdictional hurdles that may well prevent both domestic courts and the International Court of Justice to render clear, unequivocal verdicts that Germany is responsible for internationally wrongful acts or failing to discharge its duties. That doesn't mean Germany isn't currently failing to discharge its duties. It's very hard to come to any other diagnosis. But we have to understand that the litigation in international relations doesn't quite work like it does in the domestic context. So we can't really rely on a kind of court case giving us in black and white the diagnosis that Germany has failed to enact its duties under international law. Even if we get that outcome, we must understand that the International Court of Justice can ask for things like reparations But we don't have an international police force that then enforces such an order. So it's difficult to say from this point of view what materially will follow for Germany. What is absolutely clear that already Germany is undercutting its own standing in the international system. It has lost all moral authority and the capacity to appeal effectively to international law as a means of getting other states to do what Germany might want to do. So Germany has significantly contributed to the weakening of international law that we see generally, and has significantly undercut its own standing in the world. For a policy that doesn't even, in the end, in my view, serve Israel, and that has left the Palestinians absolutely abandoned.
I wanted to end with asking about what damage this affair could have on international law, on the United Nations. I mean, you've just touched on it there about Germany damaging its own reputation. But moreover, we see the United States questioning the international rules-based order, and then we see countries like Germany not applying the rules in the way that you think they should be. Could it lead to a kind of a longer-term erosion of international laws?
Yes, international law, specifically the very basic rules on the prohibition on the use of force and those meant to constrain violence where wars have broken out, they're gasping for breath. This is an absolute moment of crisis. We are in an emergency for the survival of the international legal order. And it's all the more astonishing and damaging that Germany, as a leading European country, isn't only not standing in the breach that the United States has left by changing its position on international law, but is itself contributing to this crisis in international law. We will come to regret that, and we should change course if we still can.
Professor Janina Dill, thank you very much for your time.
Thank you.